Justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule at the defense rests.
Okay, two cases are called 23 CR 7 and 23 CR 956, the state of Texas versus Hakeem Futrell. Mr. Futrell, that's you, right?
Yes, sir.
Okay, you are present here, and your attorney is Langston Adams, who's to your left, as you know. You've got a motion to revoke probation in 23 CR 7. You're on probation for robbery, and since just May of this year, is that right?
Yes, sir.
And so since then, it is alleged you've committed the offense of failure to identify on January 3rd of this year, criminal trespass on that day, aggravated sexual assault on June 27th, failing to report to the probation office, and failing to pay court assessed fees. Those are the 5 violations. And in 23 CR 956, this is a new case. It is alleged that you committed aggravated sexual assault on or about June 27th, 2023. It also alleges in this indictment that you have a prior conviction of robbery that is shown through this case, 23 CR 7, and the motion to revoke probation here. And this aggravated sexual assault is a first-degree felony if found guilty, but because the robbery is here, that enhances it to no less than 15 or more than 99 years confinement or life imprisonment. So those are very serious punishment potentials here. And of course, the robbery, you're looking at no less than 2 nor more than 10 years imprisonment if your probation is revoked. So what is Mr. Futrell's plans here, Langston Adams? What do you want?
I had talked with him. I want to talk to everybody in here
Okay. Yeah. Well, about what?
about my convictions, wrongly indictment, and throwing me in jail. This is my 7th time being in jail, and
That's a lot.
This is the 2nd time that y'all came with this story.
What do you mean, y'all? The grand jury indicted.
About
not me.
being locked up.
I didn't have anything to do. It's a grand
Can I
jury.
talk, sir? Is it my time to talk?
No, we're going to correct you whenever you're wrong for the record. Okay.
I've been quiet the whole
All
time
right.
while y'all talk.
What we're going to do is we're going to get you. You can go back and
You see,
when you can be polite, we'll bring you back out. Okay. Thank you. Let's bring Paul Solomon next. You'll be out. Go back and we'll come back later.
Every time y'all
We'll come back later. Paul Solomon is next.
And I'm tired of being locked up, man.
Paul Solomon, please.
Done on that. In the tool, good man, tank, all that.
I can understand you're having problems.
Right, on that case, Judge, I talked to him, but man, he's not trying to do nothing on that. So if you can just release me in point, we'll be on.
Well, we're going to do the motion to revoke probation first.
You want to set that for, you want to do it today?
No, for a hearing.
If you don't mind, just set it for hearing. I asked, but on those new cases, I mean, I didn't talk to him.
All I've got is just one aggravated sexual assault.
We got the robbery too.
No, the robbery is a motion to revoke probation, but we'll do them. You can,
I can handle
we'll
it.
keep you on the motion to revoke.
And then for the new.
And then
stuff,
the new case, you can be released if that's what happens. Tovar,
Sir,
Mr. Tovar. Oh, you're turning.
I'm right here, Judge.
Oh, there he is. I'm sorry, I was looking for the state. 22-411-44 is called the state of Texas versus David Allen Tovar. So you were here with your attorney, Mr. Wilkerson, and the state's attorney. This is set today, correct, everybody?
Yes, Your Honor.
For trial, but it's not, there are so many other cases that are older than it that it is not going to go to trial. And I believe you had asked, you need some additional time. Is that right?
Well, I need the records from the state, Judge, that that have been promised. That's
And-
what I need.
Who's handling that case for this?
I am, Judge, but it's just.
What's he talking about and
Well,
what's the holdup?
I think, well, I don't think there is a holdup, Judge, other than we're just waiting on the responses from the subpoenas. I show that we have subpoenaed records from Spindletop Center. Is that one?
Yes,
That we subpoenaed records from St. Elizabeth Christus.
and we have those.
Okay, you have those. And then Family Services of Southeast Texas.
I believe we have those.
Okay, and then,
Spindletop.
so all you're waiting on is Spindletop records.
Let's see. Let me verify that. So this is Christus, and then this is,
These are all entities in Beaumont. I mean, somebody can drive over there and get them if they were told, make copies, please.
I think Spindletop
Usually
usually,
we're going to Austin with that gigantic archive in the sky. And we'd have to wait forever.
so I've got Beaumont Pediatric Center, and I've got St. Elizabeth. And that appears to be,
Retry it, refresh. This is the brand. Okay.
and you have Beaumont Pediatrics.
I have Beaumont Pediatrics, and I have St. Elizabeth.
Okay, so Judge, the only thing we were waiting on is the subpoenaed records from Spindletop Center. I just got this case 2 days ago, so I don't know exactly where they're at, but I'm
Okay,
saying
so
that I'll.
you've got all the others.
I've got what appears
That
to be.
that should be, ought to be able to get that in 48 hours.
It shouldn't be a problem, Judge. We'll take care of it.
Do it in 48 hours, please, if you can. Get it over to me. Okay,
That will, that would address that issue, yes, Your Honor, but he
Right.
has been confined for more than 90 days. And
okay. That may be the way things happen in the way things are under the bond law, right? Article 17.15 of the Texas Code of Criminal Procedure is the guiding light.
in 17.1.51, the judge is what we're asking for a reduction. in.
Okay, what's the problem with y'all being ready for trial? Just those records from,
Right, once we have that, we are ready.
why don't you get it today?
Okay, well, I'm in trial myself on another case already.
Okay,
so-
well, get some help from somebody in that disregard, because all we're talking about here, you're announcing ready, and if the defendant raises this statute and argues the state was not ready within the statutory time period, the state must then make a prima facie showing of readiness for trial.
We can do it, Judge.
Or I'm compelled to lower his bond. Okay, it sounds like all this is something y'all can almost walk over and get, so get it. And what's his bond right now?
$250,000, Judge.
All right, do you want me to read out the probable cause affidavit for the record? Is that necessary?
No, Your Honor.
Okay, well, it states, according to this child, that the defendant forced her to perform oral sex on him on several occasions. And the child was 8 years of age, and the assaults continued from the ages of 8 to 14 years of age. So,
And Judge, our position on that is if the probable cause affidavit, the indictment is going to be considered evidence of guilt, then we should be allowed to present all the affidavits we have, all the facts showing why this could not have taken place.
go ahead, present them.
Well, so
You have you have a chance to be heard, but the nature of the offense and the circumstances under which it was committed are to be considered. And everybody knows in these types of allegations, these types of cases, and keeping in mind that the grand jury has deemed that this probably happened and he probably did it by the very nature of bringing forth an indictment. These are the types of cases that this article seems to affect the most, because these are generally some of the most disturbing allegations under law.
Absolutely, Judge. So in the house that Mr. Tovar lived in had 3 bedrooms and 8 people living in the home. Someone was always awake, whether it was 2 a.m, 4 a.m, 6 p.m. All of the residents of the home,
How many
including
people were there?
up to 8 at one time, Judge.
So in my house when I grew up, and people weren't awake all night long.
Well,
Okay, I have personal experience with that. So no, the lights are not always on. No, people are not shuffling around all hours of the night, every night. Sorry, no, that doesn't happen.
it has to do also with where people are sleeping, how they have to get by various people who all sharing rooms together. But everybody who resided there has completed an affidavit explaining why this couldn't have happened and that it didn't happen. Additionally, Judge,
This is the probable cause affidavit. We're going to rely on that. That's part of, I'm looking at this, that's part of the record. And it says that they were, people were watching television. She was with her, in her stepfather's bedroom, watching a movie with him. I guess that's the defendant. The stepfather is the defendant in this case. And her mother. When her mother left the room, that left him and her, according to this, only in the room. And then he forced her head under the blanket, exposed his penis, and forced her to perform oral sex. And on several other occasions, in between the hours of 4 and 6 in the morning, he enters her bedroom, gets in bed with her, and forced her to have vaginal sexual intercourse. These assaults continued from the ages of 8 to 14 years of age. The way this reads here, it can be accomplished without someone else seeing and being a part of it. Can I finish before you interrupt?
Yes.
Okay, go ahead.
In this particular case, the victim also had an external hymen that had to be treated until such time as she lost her virginity. That's contained within the Beaumont pediatric records. She kept a journal detailing all of the boys that she slept with, yet not listing my client as having abused her, although she did accuse another boy of having abused her in another instance, Judge, in the journal. There's a number of things that weigh against not just probable cause, but certainly conviction in this case. The only reason Mr. Tovar is here today is because of his prior.
No, it's because a grand jury indicted him. After they heard evidence to support their decision, if they followed the rules, which no one says they didn't. Anything else? What do you have to say in response to what he said?
Judge, I think that there's a lot of convoluted issues that they brought up. We're looking into them, but as far as we know, the complainant's still cooperative, ready to testify, and we intend to go forward.
Okay. What about this journal thing?
We've got them. We've given them in discovery. I don't agree with their interpretations of the information in that journal, and I also don't think that a child who did have consensual sex with another child would necessarily journal about how they were sexually assaulted by an adult.
Everybody's different. What else? Anything else you want to add?
I mean, she's additionally told 2 of her cousins that it didn't happen.
What about that?
I've had this case for 2 days. I can't tell you every single aspect of what they're bringing up because
have you seen that in the file?
No, sir, I have not.
Okay.
I'm happy to look into any of those kind of issues though.
Oh.
And then we'll get the records squared away so that
the decision on bond stays the same. If you want to reopen this for another bond hearing and bring forth witnesses, I'm happy to listen to it. Okay. And consider, I'm always to consider bond. And on this one, like everything else, this type of claim, we're fast tracking this. And stand by. Yeah, we want all these continuous sexual assault cases. I want them on top of dockets, on every docket. Yeah, no matter what their number is, they get put as a because of the nature of the case and everybody, the complainants as well as the defendants' lives are in jeopardy. And of the largest jeopardy that it seems like the law has. We are going to treat those most importantly, like the law says that we should prioritize, even if they're just 300 days old. Let's get this done so everybody's lives can move on. Mons says the same. I don't see anything right now that's convinced me that because of the most disturbing, it's a disturbing
Covering true crime and police arrest, where the judges move and the defense rests. Watching courts and trials, criminals at best, where the gavel drops and the defense rests. If you love true crime and you want the best, won't you find the time and the defense